Welcome. I'm Jean Carter, an ACTEC Fellow from Raleigh, North Carolina, and our guest is Catherine Ramsey.
And I'm also an ACTEC Fellow from Richmond, Virginia.
And our topic for the next few minutes is estate planning for the college-bound 18-year-old. What do you tell them? What can they do? Catherine, I know you've been through it with your son Matthew. What'd you tell him? What happened?
Well, as have you with William. One of the first problems I ran into as a parent with a college-bound student is realizing that as soon as they turn 18, as soon as they have their 18th birthday, they all of a sudden, you as a parent have no rights.
And they're happy.
And they're happy, but when you need to go and get immunization records and health forms filled out by the doctor's not going to talk to you. So one of the first things you need to do as a parent is have your child sign a power of attorney and an advance medical directive. And that will give you the right to talk to the doctors, get their records, and should, heaven forbid, the child has an accident, you will be in a position to make those decisions without a whole lot of paperwork.
Just because I'm his mother, I have no right once he's 18?
Once they're 18, they are an adult, and you have no more right to make decisions for them as you would for me or anyone else.
Well, does my 18-year-old need a will?
Well, that depends. It's a great question. The default rule in most states is if the child has assets, when they die, the assets would go to their parents by default. So if you have a situation where that would be a desired outcome, you don't necessarily need a will, but having a will is still not a bad idea because it makes it clear who's going to make the decisions. And certainly if there is a blended family where you have step-parents, maybe the child wants the assets to go to a step-parent or to siblings as opposed to the parents, they need a will to do that as well.
What about items like an IRA account or another thing of that nature? My son had those.
Well, anything that they have in separate accounts, if you can make sure that the beneficiaries are updated so that it conforms with the will. And another thing that a child may need to look at, speaking of beneficiaries, is if there's a trust in the family where the child is a beneficiary. It may be that the trust will say if something happens to the child, those assets are going to go to siblings, for example. Well, the child may also have a power to change that, which you won't know unless you review the document. But if they have that power, they can exercise that in a will that maybe redirects how those assets are handled at the child's death.
Makes sense. William also had a uniform transfers to minors account, and he had a nice 529.
Well, and the 529 in particular, it's important to make sure that that can continue uninterrupted. Usually the 529s are controlled by the donor, the parent or the grandparent who set up the account. Okay. And should something happen to them, we want to be sure that those distributions can still be made so the child's education is not interrupted. So that would be something else on the checklist for the parent to make sure that they have a successor lined up for that 529 plan to make sure that that's uninterrupted. For the UTMA, the Uniform Transfers to Minors Act, accounts that were created for the child when they were under 18, many times the financial people, the banks, so forth, they will know that the child is 18. They will not want to talk to you as the parent anymore. They say, we've got to, by law, retitle this account in the name of the child. Now, as a parent, you could look at that as, oh my gosh, I'm going to have to tell the child they're going to have this money and they're going to take it and run off with it and buy a fancy car. Or you can use it as a learning opportunity to sit down with the child, as I did with Matthew, and say, all right, you're coming with me to the financial advisor. We're going to sit down, look at this account. It's going to be in your name, but you need to know that it is not there for you to just spend on whatever you want. It is there for your college. It is there for a house or whatever. And it's a good opportunity to begin that educating process.
So Catherine, to summarize, once a child turns 18, mom has no rights anymore.
Absolutely none. We've done our job at that point in many respects, and the law says it's now time for the child to take it on their own.
Sounds fair. Catherine, thank you very much for helping us today.
You're quite welcome. Thank you.